Promotion. Item number 1.
Your Lordship, I appear on behalf of my senior CGC, Ms. Zainab Sankwi. May the matter be passed over for the time being as she is stuck in the traffic right now.
Who is item 1?
Yes, Your Lordship.
Item 1. Yes, you are there?
Yes, my lord. On behalf of my senior, he's also on his own.
Okay. Next.
Item 2.
You are not audible. No sound. No, you are not audible. Yes. What is happening? There's nobody there on duty? We can't hear you, Mr. Counsel. This is the problem. So just check up your system. We'll take it up after some time. Yes, next.
The motion again. Item 19. Supplementary cost list.
Am I audible to my lords now?
Okay, just wait, huh? Yes.
My lords, item number 2, I'm appearing for the petitioner. I'm requesting a notice in the matter. My lords, the matter pertains to issuance of, in relation to PMLA proceedings, issuance of a freezing order pursuant to which 2 of my accounts, one maintained with State Bank of India and another maintained with Axis Bank, have been frozen. My lords, the order has been issued under section 17(1)(a). If your lordships will have the act with me once,
No,
and
show me the order.
this order today has to go, my lords.
Show me the order. Where's the order?
Yes.
Page.
My lords will have the impugned order at page 46 of the petition. Your lordship has it?
Yes.
Your lordship has 46?
Yes.
Yes, my lords. My lords, this is an order of freezing under section 17(1)(a). My lords will just mark this section. I'll read out later. Whereas now the order reads in this manner that Mr. Rajesh Kumar, the Assistant Director of Directorate of Enforcement, authorized by Sri so and so Deputy Director, while authorization number so and so, for the purposes of investigation under the PMLA Act, hereby makes an order of freezing of the below mentioned accounts. Now, on the next page at serial number 12 is where your lordships will find my account.
Serial number 12.
Serial number 12. That's the account of MS Store, my lords, the petitioner before my lords. It's my sole proprietorship concern. My lords will just also notice this mentions the name of the bank on the right hand corner, SBI.
Yes.
That's the first account. Now on the next page at 48, my lords will see a letter addressed to me on 10th of June 2026 by another bank, Axis Bank Limited, which is intimated that there is a freezing order on my account. That's the second account in question. Now, my lords will just bear with me for a second, have the PMLA Act as to why I say the order today could not stand and has to be quashed. My lords will have section 17(a) of the PMLA Act and then it has to be read along with 17(4).
(17)(a).
Yes. My lords has 17(a).
Yes.
Yes. Where it is not practical. In fact, I just start with section 17 as is, Manoj, because it will have some bearing.
Just a minute.
Yes.
Just a minute. 17A is an amendment or what?
Manoj, 17A is an amendment. It was inserted by Act number 2 of 2013.
2013.
And it came into effect on 15th February 2013, Manoj.
See, my book has only 17. There's no 17A.
Manoj, if possible, we can show it on the screen as well.
So it's 17A or 17(1)A?
Manoj, 17 and then there is subclause 1A, sorry.
No, that's what? 17(1)A. This is the one. Yes.
Manoj, I'll start with 17.
Yes.
And Manoj will just have to juxtapose the section with the freezing order now. 17 says where, now Manoj will see, the director or any other officer not below the rank of deputy director authorized by him as in the director, Manoj, for the purposes of this section, on basis of information in his possession, has a reason to believe, the reason of belief to be recorded in writing, that any person may. Now, let me just pause here for a second, and my lords will juxtapose with this at 46, the freezing order, and see the order today before your lordships has been issued by assistant director, not the director, not the deputy director authorized by the director, but someone below the rank of these two. That's the first contention. Now, the subsequent part of this section deals with seizure. Now, an alternative route is provided under 17(1)A, and this is where it starts, Manoj, where it is not practicable to seize such record or property, the officer authorized under subsection 1, that is the director or the deputy director, that's the limitation placed by the section itself, may make an order to freeze such property, whereupon the property shall not be transferred or otherwise dealt with, except with prior permission of the officer making such order, and a copy of. Your lordship has 1A. Now, the first contention your lordship has seen that this is not an order that has been passed by the director or the deputy director. Now, please see, my lords, what the statutory scheme is. Because after 1A, once the notice is issued, and I have not received any such notices, be that as it may, the statutory scheme does not prescribe an infinite amount or infinite time for the authority to continue the seizure. And for that, my lords will have 17(4). Subclause 4. The authority seizing any record or property under subsection 1 or freezing any record or property under subsection 1A shall, within a period of 30 days from the seizure or freezing, as the case may be, shall within a period of 30 days from such seizure. Now, Malaj will mark these words 30 days. Or freezing.
Yes, 30 days for what?
Yes, 30 days to file an application. File an application requesting for retention of such record or property seized under subsection 1 or for continuation of order of freezing served under subsection 1A before the adjudicating authority. So therefore, Millet, a time limit is prescribed of 30 days.
Okay.
Now your lordship sees 8th of June.
Who is the adjudicating authority?
Millet's adjudicating authority is a PMLA adjudicating authority in New Delhi, Millet's.
Has it been defined under the Act? Adjudicating authority.
Malaj, it's
Come to section 2.
fine.
2A. Subsection 1 of section 6 is the adjudicating
Malaj,
authority.
adjudicating authority is defined under 2A, which then makes a reference to section 6.
It makes a reference to 6.1.
So adjudicating authority is established in Delhi, Malaj. It is working, it is there. No, Malaj,
So, Mr.
we'll
Counsel,
note
just a
one more
minute, just a
provision,
minute.
17.4.
Just a minute. There are some technical glitch here. See, preferably you should come down here to argue in person, physically, because this VC thing,
Yes,
it's
sir.
permissible, no doubt, but there's a lot of difficulty. There are technical glitches and all that, and there's no continuity of the power supply. So it's off and on. So, from what I gather from your submission, number one is that this freezing order has been issued by an authority who is not competent under the Act. And number two,
That's correct.
within a period of 1 month, if the freezing has to be retained, then the report or application has to be submitted before the adjudicating authority. And in which case, which has not been
That's
done, perhaps.
Which has not been done.
This is 2 points.
Now, as a consequence of these two, Malaj,
Yes.
the consequence of these two is, Malaj, the relief in my rare petition that this order today cannot stand and has to be quashed. That's the limited submission being made.
Correct. This is the first day, but
Yes, ma'am.
day one we don't squash like that, nah? Notice has to go.
Yes, absolutely. Malaj will have to issue notice, I understand.
Heard your good name, Mr.
Shubham Paliwal, Malaj.
Okay, heard Mr. Shubham Paliwal,
Paliwal.
learned counsel for the petitioner through RVC, who submits that the petitioner, being aggrieved with the order of freezing under section 17 bracket 1 capital A bracket close of the PMLA, 2002, dated 8/6/2026 bracket annexure 4, has filed the instant writ petition seeking quashment of the same on the ground that the same has been issued by an authority which is not competent as defined under the Act. Under section 17 bracket 1 capital A. Stop. The learned counsel submits that under section 17 bracket 4 of the Act, the authority seizing the record or property under subsection 1 capital A, this is within bracket, okay, 1A, is required to file an application requesting for retention of the record or property seized before the adjudicating authority. Full stop. Although the order of freezing the bank account of the petitioner was issued on 8/6/2026, despite lapse of more than 1 month, more than 30 days. Such application as mandated under section 17 bracket 4 of the Act has not been made before the adjudicating authority. Stop. Therefore, for these two grounds alone, the impugned order of freezing dated 8/6/2026 is liable to be set aside. Next para, in view of above, issue notice of motion returnable by 4 weeks.
May I only request a shorter date here?
Shorter date, when do you want?
Well, it's at earliest
But-
because therefore, it's a matter of my livelihood.
Okay, now who are the respondents, by the way? Directorate Enforcement, Government of India. Then CGC can appear in this? Ms. Zaram Sangpui? Are you there? Have you been served with a copy of this writ petition?
Not regarding which item, my lord?
This is item 2.
Not yet, my lord.
Have you served a copy to the CGC?
My lords, we can do it in the course of the day, my lords.
You should have served in advance. Can you appear for the Director of Enforcement?
Yes, they have another one case also. In that case, I represent them.
Sorry? They have what?
One case, then I represent them on that case.
So you're appearing on case-to-case basis, or any case filed against the Enforcement Directorate, you appear?
It seems that case to case only.
Case-to-case. Okay, that is number 1. Number 2 is Union of India through Secretary, Minister of Finance. Can you appear?
Yes, my lord, I
All right.
appear for.
So one notice should go, or what? Directorate, Enforcement Directorate.
Yes, my lord.
You will accept or will send notice?
Let's send notice.
Okay, in view of above, issue notice of motion returnable by, today's what? 23rd, is it? Returnable by 11th of August. Ms. Zaram Sangpui, Lanet CGC, accepts notice on behalf of respondent number 2. Petitioner to serve her with a copy of the writ petition during the course of the day.
So grateful.
Stop petitioner to take steps for service of notice upon the respondent numbers 1, 3 and 4 by speed post within 2 working days. List again on 11th August. All right.
So grateful, my lords.
Pass over item number 1.
May it please your lordship, the learned CGC was to obtain instruction in the previous court date
Yes, my lord.
What instructions?
as to why this case, this petitioner should not be. clubbed
Okay,
together
okay.
with-
This is that case.
Uh-huh.
What is the instruction? Who are respondent number 1 and 2?
Respondent number 1 is the Secretary Ministry of Railways. And the respondent number 2 is the Northeast Frontier Railway represented by the Deputy Chief Engineer Construction, NF Railway.
Okay, respondent 1 and 2 have failed to appoint substitute arbitrator under so and so.
Yes, my lord.
After withdrawal of the previous arbitrator.
Yes, my lord.
Similar issue had cropped up in WPC 107.
Yes, my lord.
107 was Who are the parties in 107?
107, there is only one petitioner, Lalri Noma.
No respondent.
Respondent, the same, my lord.
Ministry.
Yes,
NF Railway.
Yes, Ministry of Railways, Government of India. And number 2 is the North East Frontier Railway, represented by Deputy Chief Engineer Construction, NF Railway. Respondents are the same, my lord.
This, please explain the instruction you have received. I don't understand what is written here.
My lord, I am also.
Very fine English.
However, as far as my understanding, my lord, the appointment has been made only after compliance of the court order. It seems that
Compliance of the court order.
yes, in compliance of the court order only. Judgment and order for direction of appointment of arbitrator is compliance by them. Oh, okay, it's okay. Supposing direction may be given, similar direction may be given again in this case, they may be appointed another arbitrator.
Okay, what was the direction given? Where is the direction?
The
In
direction
the
given-
earlier case.
Page 118, my lord.
Please write. Heard Mr. Zoram Chanalane, counsel for the petitioners. And Ms. Zaram Sampui, Lanet CGC. Preparing for the respondent numbers 1 and 2. Correct?
Yes, my lord.
And Ms. Lalun Louis, Lanet government advocate for respondent numbers. Respondent number 3. Stop on 16/7/2026, court passed the following order. Please abstract the entire order. Today, we'll learn it. CGC, Ms. Zaram Sampui submits that the instructions which has been given to her by letter dated 22/7/2026 is that in WPC number 107 of 2025, there was a specific direction from this court for appointment of fresh arbitrator. And accordingly, the arbitrator was appointed. Stop. Therefore, in absence of any direction in the present case, the respondent authorities are not in a position to appoint arbitrator. Stop. In support of her submission, she has produced the communication dated 22/7/2026. The same is kept on record and marked as X for identification. Next para. From the projection of the petitioner, how many? One only? No, more than one. Projection of the petitioners. Their grievance is that respondent numbers 1 and 2 have failed to appoint as substitute arbitrator what was the reason to the
The reason is that the previous arbitrator had resigned, my lord.
in view of the resignation of the previous arbitrator? Because he retired, that's why.
Yes, my lord.
One has to be in service or what?
My lord, he has.
I don't think so.
He has sent a communication, my lord. Is that page 109, annexure 11. He had requested the railways to appoint a new arbitrator in his place.
Okay. He says he's heavily, I mean, he's got a lot of burden on his shoulders.
Yes, my lord.
Resignation of the previous arbitrator. Okay, stop. The learned counsel submits that a fresh arbitrator can be appointed under section 20 dash capital F bracket 6 of the Railways Act, 1989. Read with Rule 3 of the Land Acquisition, open bracket, special railway projects, close bracket, rules, 2016. He also submits that similarly, in case of WPC number 15 of 20, in case of WPC number
107, my lord.
not 107, 15, is it 15?
2025.
Last time Ms. Zainab Sampuri had produced.
There are so many, there are a number of cases disposed of, my lord.
Okay. In case of WPC number 107 of 2025, along with other writ petitions, one Mr. Vinod K. Kavle or Kavi? Kavi. Kavie IAS has been appointed as an arbitrator. And therefore, court may direct the respondent numbers 1 and 2 to appoint an arbitrator in accordance with the relevant provisions of the law.
My lord, I think it's Kavle, Kavle.
Kavle. I don't know, you've given me such a copy which has to be, like you have to send it to the FSL to find out what is this. And it's not very, the person may take offense to this also. If you reflect the name wrongly, this is the problem, you see. Ms. Zainab Sampuri, can I help us? Whether it's Kavle or Kavi?
My lord, L-E.
Huh?
Kavle.
L-E, are you sure?
L-E. Yes.
Kavle.
Oh,
Kavle, okay. Next para, considering the above submissions and the instructions received by the learned CGC, the writ petition is disposed of by directing the respondent numbers 1 and 2 to appoint a fresh arbitrator in accordance with law. L, it's correct? Okay. In accordance with law as expeditiously as possible and at any rate within the outer limit of 6 weeks from the date of receipt of a certified copy of this order. For disposal of arbitration case number
7, my lord.
7 of 2020.
2020, just 1 minute, my lord.
Which year?
7 of 2023, my lord.
2023. Should we make an observation regarding this Kavle? They may use him also.
Yes, my lord,
I
this.
think he will be appointed, my lord, because he will take up the entire case.
Ah.
There is no need for appointment of a new.
It is also made clear that the respondents are not precluded from appointing Sri Vinod P. Kavle, IAS, as an arbitrator for the present case as well. Okay. This order dated 16/7, you're abstracting it, okay? You have to abstract in the beginning I've given you. On so and so, put past the following order. So out there, you just correct the spelling also. Sri Vinod P. Kavle is there. Okay, you make it Kavle. Out here it's written Kavi. Give the correct one.
Right, my lord.
Like,
Item 19 for motion.
Here, my lords, what happened is that the respondent number 1, the enforcement directorate had provisionally attached my property, my residence. And subsequent to their provisional attachment, they had filed a complaint to the respondent number 2, that is the adjudicating authority. And the adjudicating authority had issued me a show cause notice to show cause as to why the provisional attachment should not be confirmed. So I'm challenging the provisional attachment as well as the subsequent show cause notice, mainly on 2 grounds. One is that
Where are the page numbers?
the provisional attachment is at page 46 onwards, my lord. So, my lords, let me just give the short genesis of the case, my lords.
Surely, before that, you just point out the page numbers. Provisional attachment is 46.
46, my lords.
And adjudicating authority's order, show cause notice,
Show cause notice is from 207 onwards, my lord.
207. 207. Show cause notice. When was it issued? What is the date?
It was issued on 24/6.
Where do we get the date? Date
It's
is-
signed there, my lord. It's digitally signed. The date
Where?
is there.
Where is it signed? Page numbers?
209, my lord.
209. Digitally signed on
The year is given first. 2026-06-24.
24.
Yes.
24/6/2026, correct?
Yes, my lord.
24/6/2026. Okay, now tell us. What is
If
the
my lords may come to page 47. This is the provisional attachment, my lords. Here, my lords, the serial number 2, material before the authority. Now, based on these FIRs and charge sheet and all the documents, a criminal trial has been initiated against the present petitioner, along with other co-accused. Now, since the petitioner was charged under several penal sections of the IPC, then the Enforcement Directorate had initiated these present proceedings, my lords. The reason is given in page 49, my lord. From the middle portion, my lord, whereas, may I read, my lord?
Yes.
Whereas PMLA 2002 is an act for prevention of money laundering as defined under Section 3 of the Act, and the proceedings provide for attachment and confiscation of the proceeds of crime as well as prosecution under Section 44 and 45 of the Act. The offense under Section so and so fall under, these are the sections which the present petitioner have been charged in the said criminal trial, my lords. The offense under Section so and so fall under paragraph 1 of Part A of the schedule appended to PMLA 2002. Therefore, the matter was examined at the Aizawl Sub-Zonal Office and inquiries were initiated against the accused persons and others in file number so and so dated 7/10/2024. So what happened was that since the petitioner along with other co-accused were charged under these sections, then the Enforcement Directorate had initiated their own proceedings. And the allegations made against the petitioner starts from page 70, my lords.
70.
70. Para 7.2, receipt of funds by national business enterprise. Here the present petitioner is a authorized signatory of the national business enterprise. It's a proprietorship, but it's in the name of her mother, his mother. But the present petitioner is the authorized signatory of this NBE. So here the main allegation against the petitioner was that he had, in connivance with other co-accused, they had made fake car loans and they had received a number of amounts to their account, to the NBE account. So subsequent to that, my lord, the bank accounts have also been attached, but that is not the issue here. And if my lords will come to page 72, the enforcement directorate had alleged that a sum of around rupees 5 crore is still lying with the petitioner. So in lieu of that, they have attached the property, the residence of the petitioner here in my lords. If my lords will see the last paragraph of page 72. In this case, the immovable properties held by him represent value equivalent to the remaining proceeds of crime. Accordingly, the following immovable properties to the extent of rupees so and so are liable to be provisionally attached under section 5 of the PMLA 2002. And in the next page, the details of the property is given, my lord. The property was purchased by his mother in the year 1975 and it was inherited by him on 23/11/2023. So my submission with regards to this provisional attachment is that, my lords, the property was never acquired through the proceeds of crime, my lords.
Now, what does the show cause notice say? See, this is an attachment under what provision?
Under section 5(1) of the
5(1).
PMLA, my lord.
Let us see what is 5(1).
My lord.
You have a copy?
My lord. May I read, my lord?
Read.
Attachment of property involved in money laundering, 5(1), where the director or any other officer not below the rank of deputy director authorized by the director for the purpose of this section has reason to believe, the reason for such belief to be recorded in writing on the basis of material in his possession that A, any person is in possession of any proceeds of crime. Here, my lord, I want to stress on the word proceeds of crime. And B, such proceeds of crime are likely to be concealed, transferred, or dealt with in any manner which may result in frustrating any proceedings relating to confiscation of such proceeds of crime under this chapter. He may, by order in writing, provisionally attach such property for a period not exceeding 180 days from the date of the order in such manner as may be prescribed, provided that no such order of attachment shall be made unless, in relation to the scheduled offense, a report has been forwarded to a magistrate under Section 173 of the CRPC, or a complaint has been filed by a person authorized to investigate the offense mentioned in that schedule before a magistrate or court for taking cognizance of the scheduled offense as the case may be, or a similar report or complaint has been made or filed under the corresponding law of any other country. So, my lords, the proceeds of crime is defined under in section 2, subsection U.
Yes. You want to read that?
My lord. Proceeds of crime means any property derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offense. I may pause here, my lord. So the property attached here is not the property obtained or derived directly or indirectly by the petitioner through any criminal activity, my lord. But as defined in the PMLA Act, my lord, the proceeds of crime means any property derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offense, or the value of any such property, or where such property is taken or held outside the country, then the property equivalent in value held within the country. So my first point is that, my lord, since the property provisionally attached is not a property obtained directly or indirectly by the petitioner through any criminal activity, my lord.
Okay, you have shown me some, that thing, that inherited from his mother or something like that. Where's
Yes,
that?
yes.
Page?
73, my lord. Table is given there at the top, my lord. Property details. LSC number so and so, for plot number so and so, situated at so and so, which was purchased by his mother, namely Mrs. Lian Thomi, in 1975 and inherited to him on 23/11/2023. So in their provisional attachment order itself, they had stated that this is not the proceeds of crime, my lord.
So this LSC has been attached.
My lord.
And below that, 7.3, what is this?
7.3 is not concerned with me, my lord. This provisional attachment relates to more than 10 accused, my lord. So
Okay.
here I'm arraigned as a defendant, one of the defendants.
Where is your name?
My name starts from page 70, my lord. This is the allegation made against me. 7.2.
National Business Enterprise.
Yes.
MMFSL, what is MMFSL?
It's a Mahindra and Mahindra Financial Services Limited, my lord. They used to give car loans.
Correct, there was some issue regarding that also, isn't it?
Correct, correct.
These are all connected. Fake accounts and all that.
My lord.
So what is the justification given here for
The justification given is that the
attachment?
at page 72, my lords, in the last paragraph. Sorry, the second last paragraph. Starting from hence, my lord. Hence, after adjusting the attached amount of rupees so and so, the balance proceeds of crime remain as rupees so and so, which is used by Sri Paul Thanpuya. So their allegation is that the proceeds of crime amounting to this much of money is still remaining with me. So in lieu of that, they have attached my property.
Then now show cause notice.
Before that, my lord, at page 139, subsequent to this provisional attachment, the respondent number 1 had filed this original complaint, praying for confirmation of the provisional attachment, because the provisional attachment can be can remain only for 180 days as per the act. And their prayer is at page 200.
Adjudicating authority.
No, the enforcement directorate.
No, 139 is a prayer made before the adjudicating authority
Correct, correct, madam.
for confirmation of the
Provisional attachment.
provisional attachment.
Yes. Prayer is at page 200.
What is the process before the adjudicating authority?
The process is that
Application is submitted, then
I was given the
show cause notice.
reasons of recording of reasons by the adjudicating authority, then the show cause notice. And hearing will be conducted, and the decision lies with the adjudicating
When
authority.
is the hearing?
I was given time till tomorrow to respond, my lord. So that is why I have an interim prayer as well, my lords. And the same issue
What is your
Interim prayer is to stay the operation of the show cause notice, my lords. Because this same issue which I've raised in this writ petition is pending before the principal seat. And I've supplied a copy of the order also, my lords.
Principal seat? Means
Yes.
Which case?
Of this honorable court, my lord. A coordinate bench had stayed the show cause notice.
Which show cause notice?
The show cause notice issued by the adjudicating authority.
In which case? Same case?
No, not same case, but the same set of facts, my lord. Because, my lords, I have not come to the constitution of the adjudicating authority. As per section 6, the adjudicating authority...
What is the ground for your challenge to this? Now you say that the attachment has to be done on the property which is derived from the what do you call
Proceeds of crime.
proceeds of crime.
Yes.
But in this case, they themselves have stated that this is inherited by you from your mother.
Correct.
So they could not have attached that property
Correct, my lord.
since it's not a proceed of crime.
My lord.
That is your
That
basic
is
point.
my ground number 1. Number 2 is that, my lords, if my lords will see the show cause notice again,
Yes. That page.
it starts from 201, my lord. This is the recording of reasons.
201.
Yes.
That's why the date is given here, 201.
Yes, 24/6/2026. And it is issued by the chairperson acting adjudicating authority at page 206.
What is your second point?
Second point is that, my lords, if my lords may see the act again,
Yes. Which one?
PMLA Act, section 6,
Which section? 6. This show cause notice is issued under what provision?
under section 6, my lords.
6.
Sorry, my lords, it's
6 is composition.
it's under section 8. Show cause notice is issued under section 8. But, adjudicating authority is conducted by the single member, my lords, which is in violation of the act, my lord. It's not consonance with the act.
No. Just because it has been signed by the chairperson, acting chairperson, can you say that there are no other members? Thus the show cause notice required to be signed by all the members and the chairperson.
Yes, my lords. Because if my lords will see subsection 15 of section 6. Subsection 15, my lords.
Yes.
The adjudicating authority shall not be bound by a procedure laid down by the CPC, but shall be guided by the principles of natural justice and subject to the other provisions of the Act. The adjudicating authority shall have powers to regulate its own procedure. Now, in exercise of this section, my lord, the adjudicating authority had regulated its own procedure, which I have annexed here, my lord. There, my lord, it says that the order sheet, the order or the issues have to be signed by the chairperson and the members, my lord.
Where?
Page 211, my lord. If my lords will see just below the notification. In exercise of the powers conferred by subsection 15 of section 6 of the Prevention of Money Laundering Act, so and so, the adjudicating authority, so and so, the relevant portion is at page 218. (26), my lord. Issue of order. The order supported by reasons recorded shall be pronounced in open court and on the date fixed in that behalf. Every sheet of the order shall bear the signature of the chairperson and members constituting the bench.
So the other matter in Gauhati, principal seat, what was the issue there?
The issue there was also regarding this, the quorum of the adjudicating authority.
Quorum?
Yes. Section 6, 2.
Six. What is this Eastern Institute for Integrated Learning and Management University?
Here, my lords, the Honorable Sikkim High Court had directed the Enforcement Directorate to appoint a judicial member in consonance with the Section 6.2 of the Act. And this judgment was challenged by the Enforcement Directorate before the Honorable Supreme Court, as stated here, but that has been withdrawn, my lord.
Has been withdrawn.
My lord.
Okay, so we'll issue notice.
So, yes, my lords, and if the impugned show cause notice may be stayed for the time being, my lords.
Heard Mr. Sitlan Thiakema, learned counsel for the petitioner, who submits that the petitioner is aggrieved with the provisional attachment order number 2 of 2026, dated 25/3/2026, bracket annexure 1, and the show cause notice dated 24/6/2026, bracket annexure 3. So he submits that the
My lords, the show cause notice is annexure 3 and 4. It's a continuation. 3 is the recording of reasons and 4 is the show cause
okay,
notice.
put 3 and 4 then. He submits that attachment order has been issued under section 5 bracket 1 of the PMLA Act, 2002. Referring to, what was that? Sale proceeds?
Proceeds of crime.
Where is that?
Section 2U.
The learned counsel submits that such attachment can be done on proceeds of crime as defined under section 2U of the same act. Stop. In the present case, the property attached by the Enforcement Directorate is a property acquired by the petitioner from his mother, inherited by him from his mother, and therefore the same not being a proceeds of crime, the attachment, the provisional attachment of the property is illegal. Stop. The learned counsel further submits that the show cause notice has been issued and signed solely by the acting chairman of the Enforcement Directorate. So he submits that. The adjudicating authority under section 6 bracket 15 has been authorized to devise its own method for adjudicating the cases, and accordingly the adjudicating authority bracket procedure regulation, 2013 has been framed, wherein as per regulation 26 bracket 2 comma, every sheet of the order is required to be signed by the chairperson and the members constituting the bench. However, in the present case, the show cause notice has been solely signed by the acting chairperson. Of the adjudicating authority. Stop. The respondent authority concerned, having violated its own regulation, the impugned show cause notice is not maintainable and should be set aside. Stop. The learned counsel submits that a similar issue had cropped up in WPC number 3436 of 2026 bracket MS Global and Trade versus the Directorate of Enforcement and another close bracket in the principal seat of this court, wherein a coordinate bench of this court, by order dated 26/6/2026, had issued an interim order staying the show cause notice impugned in the said writ petition. Stop. The learned counsel praised for a similar direction in the present case as well. Next para, in view of above, issue notice of motion returnable by 3 weeks. Petitioner to serve notice to the respondents by, no, right like this, petitioner to take steps to serve for service of notice upon the respondents by speed post within 2 days, 2 working days. Now, stop. Having regard to the projection made by the petitioner, in the interim it is provided that the impugned show cause notice dated 24/4/2026 bracket annexure 4, 3 and 4
It's, my lord, 24-6.
I'm sorry. The other one is 24-6 also. Or 24-4.
Provisional attachment is 25-3. And the show cause notice is 24-6.
Both the show cause notice.
Yes.
Not both. One is what? One is the
One is the recording of reasons.
recording of reasons.
Yes. Same date with
Same
the show
date.
cause notice, yes.
24-6-2026, next A 3 and 4 shall remain state till the next returnable date. This is the matter again. When do you want it? Well, I said 3 weeks.
18th August, my lord.
Okay. List again on 18th of August.
I'm deeply obliged.
Item 20.
Here also, my lords, I've taken similar grounds, but the facts is a bit different. Here, the petitioner is not any of the accused, but her husband is one of the accused. And the allegation against her is that through the funds received by her husband, property has been purchased in the name of the petitioner. So they have attached the property. But I'm not any of the accused in any of the proceedings, my lords. Only in this matter, my lords. In any courts, I am not the one of the accused. Instead, my husband is one of the accused.
So what have you challenged here?
Same thing, my lord, the provisional attachment as well as the show cause notice. But the reasons for the attachment is different as compared to the
Okay,
previous
show
case.
me the which page numbers.
The allegation is
Not allegation, the impugn orders page.
46. This is the provisional attachment order. They have issued a common provisional attachment order for all the accused. That is why it's a bit bulky, my lords.
Okay, 46 is the attachment.
Yes.
And relevant portion? in your
Relevant
case?
portion starts from page 99.
99.
Para 7.5.8.
What has been attached in your case?
At page 100, my lord, the next page. One property situated in Silchar. This was alleged to have been purchased from the funds received through my husband. Tushidas is the present petitioner.
Okay.
Only that is different. Otherwise, the grounds, everything is similar.
So out here, I think you cannot take that plea. That
Yes.
is
Here
proceeds
I
of crime.
Yes, I have taken the plea that the amount which I spent for purchasing the property, there is no proof of any sort of proof that the amount is the proceeds of crime received by me. That is the plea taken by me.
And the show cause notice?
Show cause notice starts from 211. That is the recording of reasons. Then the annexure 3 and 4 again. Date also is similar.
Annexure 4 is at page number?
Annexure 4 is at 217.
Okay. You type similar order, huh? And send it me with the file. Slight modifications required. I'll do that later on.
Item 21.
Here Here, my lords, here also I raise similar grounds, but the fact is also different. The provisional attachment order starts from page 46, annexure 1.
Date is different, is it?
No, my lord,
Date is same.
same,
Okay,
25/3/26.
okay,
It's a common order, my lord.
okay. Then
And the allegation against me starts from page 62. Roman 2. Here the allegation against me is that, my lord, I had one plot of land located at Chite, here in Aizol. And that plot of land had been purchased by one of the accused in the criminal trial. And it has been utilized as a servicing center for these Hyundai cars. So since they have alleged that the purchase amount was from the funds obtained through fraud, through the fake car loans, then my property has been attached. I'm not named in any of the charge sheet or FIRs, but since I have sold my property to one of the accused, then my property has been attached,
you sold your property to one of the accused person.
my lord.
So you've already sold it.
Sold it, but the amount has not, I have not received the amount in full. So I'm still the registered owner of the property, yes.
What has been attached? Your land has been attached.
My land, my lord.
You have sold it, but you have not received the entire amount.
My lord. But it has been utilized by the purchaser already. But I have not received the amount in full.
So this land LSC has been attached.
It's not written as LSC, my lords, at page 69, my lords.
No. It is written as what?
It's, the table is given there at page 69, my lords. We are concerned with serial number 2. CK Hyundai Service Center located at Chite, Aizol. Then the proceeds of crime diverted 2 crore 30 lakhs. So this is the amount I have received, 2.3 crores. So they have alleged that the 2.3 crore is the fraud amount.
So what has been attached? What is attached? The property.
Property, yes, my lord.
So this CK Hyundai service is not functioning now.
It's still functioning since the provisional attachment has not been confirmed as of now. It's still functioning.
Okay. And that's it. Then the show cause notice.
Show cause notice starts from here also annexure 3 and 4. 210 onwards, my lord, page. This is the recording of reasons. And show cause notice starts from 216.
Okay. Okay, this also you type same order, like 19. Send me the file. So notice and there'll be stay also.
My lord, I'm deeply obliged.
Models list, item number 10.
This is the case that was taken up on Monday, wherein I have stated that the notice upon the respondent number 2 is still incomplete. I have given one letter that has been sent to the Ministry of Home Affairs, wherein we have asked about the current political scenario and the applicability of the guidelines. In this regard, my lord, we have sent a letter on 20th April, and till now we have not received any updates on this.
So what is to be done?
My lord, In that case, my lord, since the respondent number 2 has been booked only under the Foreigners Act, I think we can proceed with the case on the and the respondent number 2 may be given some
Yes.
legal aid counsel, my lord.
You have filed criminal petition.
Yes, my lord.
Under what provision? For what?
My lord, this is a discharge order,
Discharge.
wherein the learned trial court has discharged all the respondents accused on the ground that there are some violations of the provisions of NDPS Act.
So do we list it for admission then?
My lord, there's a delay application, IA.
Oh, I is there.
Yes, my lord.
Oh,
There's some delay in filing the instant application. It's 56 days delay.
yes. Any objection?
We have already filed our objection, but
So you file objection, that means you have objection.
yes, madam.
My lord, should the respondent number 2 be represented as well in this case?
What is to be done?
If I may suggest, my lord, a legal aid counsel can be appointed on her behalf.
So respondent number 2 is from Myanmar.
Yes, my lord.
Please write Miss Linda L. Fumble, learned public prosecutor, submits that notice to be sent to respondent number 2 has been routed through the Ministry of Home Affairs. And since the respondent number 2 is a Myanmar national, so a communication in this regard was sent by the Joint Secretary to the Government of Mizoram Home Department to the Director, bracket OCI and CC, close bracket, Ministry of Home Affairs, Government of India, New Delhi, on 24/2026, but till date, there is no response to the same. She submits that the respondent number 2 at any rate has been booked under the Foreigners Act, and if this court pleases, matter may be proceeded with. And if found necessary, a legal aid counsel may be appointed to represent respondent number 2. Stop considering the fact that this matter is pending since the year 2024 for want of service of notice to the respondent number 2. This court is of the view that respondent number 2 may be represented by a legal aid counsel. Stop accordingly. Who is Zaudin Sanga? He has come.
Maybe
Okay.
it's upstairs, madam. It's in the other.
Mr. H. Zodin Sang, learned counsel, is appointed as the legal aid counsel to represent the respondent number 2. Learned public prosecutor shall serve him requisite copies of the interlocutory application as well as the criminal petition within 2 working days. List the matter again. After a week,
After.
one more line. Mr. Lalbi Agnu Athamte, learned counsel, appears for respondent number 1 and submits that he has already filed his objection to the IA.
Item 11.
Your Lordship, this is bail application under Section 483 BNSS, relative to Section 37 of the ND&PS Act. Your Lordship, this bail application is listed for the first time, if notice may be issued.
What is your good name?
Elias Ramsuana.
Heard Mr. L.S. Ramswana, learned counsel for the applicant who submits that by filing this application under Section 483 BNSS, read with Section 37 of the ND&PS Act, the applicant prays for his release on bail. The learned counsel submits that the applicant was arrested by the police on 18/5/2023. No. When were you arrested?
He was first arrested on 18/5.
That was first. Now you are arrested again.
Arrested again on
When?
6 January 2026.
You're habitual. Where's that? Where's the date? Was arrested on? You have not given the facts. How you arrested?
Your Lordship, we submit the bail cancellation order, and in the bail cancellation order it was written the date of arrest.
What do you mean bail cancellation order? This is an application for bail. You cannot apply for cancellation of bail.
Your Lordship,
Bail is not yet
his-
granted to you.
His first bail application,
See, Mr.
was-
Counsel,
Yes.
your first bail application was allowed.
yes,
But then you were again arrested in connection with some other case.
yes, my lord.
Correct? So when was that arrest?
He was arrested on 6 January 2026
Where have you stated that?
in the bail cancellation order, my lord.
Why not state that in your bail application here? Where's your bail cancellation order?
Our bail cancellation order is not in our main petition, my lord. We submit on the later stage.
So you have not given the facts in your bail application. Why should we not dismiss it right now? How do we know that you are arrested? Unless you mention here that I was arrested on this date.
Your Lordship, we mentioned on para 12 of,
12.
yes.
That is what I've been asking you. You're saying that we have not mentioned anywhere. Para 12 where? Which part?
We did not mention the date of arrested.
When was the bail cancelled? Bail was cancelled by an order, isn't it?
Yes,
By
ma'am.
which order?
Your Lordship, the bail cancellation order was not passed. However, when we filed this bail application, the court asked to supply the bail cancellation order, and we have applied for the bail cancellation order by CTC, and we get the CTC of the bail cancellation order, my lord.
What is the date of cancellation?
19-4.
Show me that. Is that the cancellation order? Is that the cancellation order?
Yes, my lord.
What have you written? Last slide. (18/5/2023). In connection with seizure of 414 grams of suspected heroin. Stop accordingly. Special Narcotics Police Station case number 33 of 2023, dated 18/5/2023, under section 21 bracket C / 29 bracket 1 NDNPS Act, read with section 14 capital A of the Foreigners Act 1946 was registered. Stop. The applicant submitted a bail application number 23 of 2025. Before this court. And bail was granted to him. Do you know the date of the order by which bail was granted?
It's bail application number 23 of 2025.
Is it 22 or 23?
23.
So that I've already mentioned. I'm asking you about the order on which date you were granted bail.
It was 21.
Is it 21/7?
21/7, my lord.
What did I say? Right, order dated 21/7/2025. See, I don't know what kind of bail application you have drafted. What is the subsequent case registered against you in 2026? Case number?
Indian NPS case number 25 of 2026.
Where is that? Is it not required to be written in your bail application?
My apologies, my lord. We did not mention the case number.
Then, on what basis are you seeking bail then? You are still stuck with that 2023 matter. 2023 case, you have been granted bail, but in the meantime, some other case was registered. What is the last line? Then, that much. Stop. While on bail, another case was registered against the petitioner. Namely, what is the case number?
Indian NPS case number 25,
NDNPS case number
25 of 2026,
25 of 2026. Under section
21C.
21 bracket C of the NDNPS Act. And for which reason the bail granted to him was cancelled by order dated 19/4/2024. No, that excise case number, no? What did I say? NDNPS case number. Just read the sentence again. Namely, from there, the rest you cut. Namely, excise case number N-1/26, dated 7/1/2026, under section 22 bracket C of the NDNPS Act, and therefore, bail granted to him earlier was cancelled. Stop. Although the applicant, approached the learned special court, NDNPS Act, for bail, but the same was refused, and therefore, the instant bail application has been filed before this court. GF above issue notice, returnable by Miss Linda.
My lord,
When should we list it?
next week, Tuesday.
Returnable by 28th of July. Not Tuesday, have it on some other day.
Wednesday then. Thursday then, my lord.
Returnable on 30th of July 2026. Ms. Linda L. Fumble, learned public prosecutor, accepts notice on behalf of the state. She shall produce the case diary and instructions on that day. This is item 11.
Item number 12.
Your Lordship, this is bail application under section 483 of BNSS. Your Lordship, the applicant was arrested by excise personnel on 17/5/2026 for the alleged involvement with seizure of 25 grams of suspected heroin. Your Lordship, this bail application was listed for the first time, if notice may be issued.
How many things were, how many items were seized from you?
25 grams.
25 grams. What about these 4 grams of yellowish powder, 87 grams of dried leaves, 29 grams of powder?
From his co-accused. Co-accused, his co-accused.
You come to your paragraph 2. How have you drafted, you see? You're all mixed up. Please read the sentence. Let's see.
Then the brief facts of the case as per the prosecution is that 25 grams of yellowish powder suspected to be heroin was allegedly seized from the applicant on 17/5/2026 and was arrested on 17/5/2026 at 5 p.m. for alleged offense punishable under Section 21B of the NDNPS Act. 4 grams of yellowish powder suspected to be heroin and 87 grams of dried leaf suspected to be ganja was seized from his co-accused Rosiam Lianralte, and another 29 grams of yellowish powder suspected to be heroin was seized from another co-accused Jerry Kailal Trazola, and he is in judicial custody till date.
So, how many applicants are here? Only one.
Only one.
Why do you have to mention all these?
Your Lordship, and his co-accused Rosiam Liana is released on bail by this honorable court.
Oh, heard Mr.
Elias Laram Suana.
L.S. Balram Suwanu, learned counsel for the applicant who submits that by filing this application under section 483 BNSS, the applicant pays for grant of bail. Stop. He submits that the applicant was arrested on 17/5/2026 in connection with recovery of 25 grams of yellowish powder suspected to be heroin. And since then, he is in jail. Stop. He submits that accordingly, excise case number N-141/2026 under section 21 bracket small b, comma 21 bracket small a and 20 bracket small b bracket small Roman 2 capital A of NDNPS Act has been registered. Issue notice to the state returnable by
Your Lord, can you be taken on tomorrow? Tomorrow.
why? Who are you to decide tomorrow? They have to produce their case diary and all that.
It will not be possible tomorrow.
Same date, okay, Ms. Linda?
Yes, madam.
Returnable by 30th of July 2026. Ms. Linda L. Fumble, learned public prosecutor, access notice on behalf of the state. She shall produce the case diary by the next date. List accordingly on 30th of July 2026.
Obliged.
Obliged.
Item 13 to 14.
May it please your lordship, I am appearing on behalf of the state respondents. Your lordship, in this alia appeal, the state respondents have filed a cross objection, and there is a delay of 170 days in filing the cross objection. And notice has to be issued, Your Lordship. This matter has been listed for the first time after filing of the cross objection and the IA for condemnation.
LA appeal is filed by whom? You filed.
Yes,
LA.
Your Lordship.
You filed cross objection.
Yes.
Yes, Your Lordship.
With
In
IA, Your Lordship.
IA is connected in connection with cross objection.
Yes, Your Lordship.
See, Mr. Siata, come here. How the nomenclature is given, how it is listed. You see, IA is for delay condonation in cross objection. Serial number 13 is given separately, 14 given separately. What is the requirement? Cross objection can go separately. IA so and so in cross objection so and so. LAP will go separately. They've all mixed up everything. What is happening? This application is filed by the state.
Yes, Your Lordship.
Got Ms. Lal Nunlui, Learned Counsel, Learned Government Advocate, appearing for the applicant who submits that by filing this application, the applicant, one or two, how many of them are there?
4, Your Lordship.
Okay, you put S, okay, the applicants seek condonation of
170 days, Your Lordship.
170 days in
Yes,
filing
Your
the cross objection. Filed against the judgment and order of the additional district and session judge Roman 2 Aizol in LA case number 40 of 2015. Issue notice returnable by
Your Lordship, may I have instruction from my senior counsel to pray 2 week times for filing objection in IA. To pray 2 week times for filing objection in IA.
2 weeks time.
Yes, Your Lordship.
Returnable by 2 weeks. Mr.
Lal Thangmoya.
Lal Thangmo, a learned counsel, appears for the opposite party and prays for 2 weeks time to file objection. Notice is therefore complete and 2 weeks time is granted as prayed for. Just again after 2 weeks.
Item 15 to 16.
Your Lordship, in this LA 17 of 2025, the LA case, the impugned LA case is LA case number 39 of 2015.
This is 15 and 16, correct? Before that, that will be in item 13. Item 14, write this order. List this matter along with CO number, no, along with ISC number 101 of 2026, arising out of CO 2 of 2026. Okay. Okay, now 15, 16. What is this?
Your Lordship, that is also for the IA is 102 is for condemnation 170 days in filing the cross objection number.
Your IA number is 102
Yes, Your Lordship. IA is 102.
in connection with CO3, isn't
Yes,
it?
Your Lordship. Yes, Your Lordship.
So these two should have been listed together. And LA could have been listed separately.
Yes, Your Lordship.
It's just the opposite now. So somehow it goes to show that the impression has been created that this IA is arising out of the LA appeal. How many days?
170 days, Your Lordship.
Same, Your Lordship.
Same, okay. Similar
Yes, Your
order, okay. Then in item 16 you write, list this matter
Your Lordship, if I may, the item number 16, the LA 17 arises out of judgment order dated 17/12/2024 from LA 39 of 2015, Your Lordship.
Okay. Just a minute. Similar order I said, but case number is different.
Yes, Your Lordship.
Similar order, but only changes is that against the order passed by the learned additional district and session judge Roman 2 Aizawl in LA case number 39 of
yes.
2015.
Yes, Your Lordship.
That is different. Okay, the remaining is same. This is an item 15. Then item 16, you write list this matter along with IAC number 102 of 2026.
Item 17 to 18.
17, 18 also, Your Lordship. The IA 103 is for continuation of 170 days arising out of the cross objection 4 of 2026, Your Lordship.
Okay, similar order. Only difference is that the LA case number is 17
Yes,
of
Your Lordship.
2015.
Yes, Your
okay.
Lordship.
Remaining is same. Then in item 18, you write list this matter along with IA C number 103 of 2026.
From admission list, item 3.
May I please, Lordship? My Lord, my Lord, as instructed, I filed a recast petition, my Lord.
Recast.
Yes, my Lord. We have prayed the amendment of the pleading, the same was allowed, and we were instructed to file recast petition, and the same was done. And
What was the requirement of recast?
my Lord, actually the substantial question of law proposed by me was
Oh,
in a spreadsheet, my Lord, not in the memo of appeal.
oh, I see.
That was the reason why I was instructed to file amended application. The same was allowed by this honorable court, and recast petition was also done.
No, but Mr. Lianshima,
My Lord,
apparently, I think the same mistake has been committed.
my Lord.
Substantial question of law proposed is after the affidavit.
No, my Lord, it is after para 7, para 7A.
Okay, 7A.
7A is the amended portion, my Lord.
But 21A remains.
Remains, we should have, the same is useless. I mean, we should have torn it off, but we failed to do it. So. Rather than making many changes, we we try to
Yes.
make it remain as it is.
Okay.
So,
Now,
if your Lordship is of the view that the substantial question of law, 3 substantial question of law proposed by me is acceptable to your Lordship, then say maybe the instant second appeal may be admitted on the 3 substantial question of law, my Lord.
yes, but what is the case? I'm not aware
Case-
about the
oh, my
facts
Lord,
of the
my
case.
Lord. I'm sorry. Facts of the case in brief is that the present second appeal is directed against the order passed by the district judge as well as the order passed by the senior civil judge in civil suit number 77 of 2018, my lord. Facts in brief is that the LSC of the respondent number 5 has overlapped the LSC of the pro forma respondent, my lord. Hence, the respondent number 5 instituted a civil suit number 77 of 2018 against the state respondents, challenging the order dated 3/11/2017, issued by the respondent number 3, that is the Director of Revenue. During the pendency of the said suit, respondent number 5 filed application under section 151 of the CPC for transfer of his LSC location from Phunchong village to Zounom village. As a result, the Lane Senior Civil Judge passed the impugned order without verifying whether the said vacant land is really vacant at the relevant time of the application, or without knowing whether he has jurisdiction to do so, and that too without giving opportunities to the parties concerned, my lord. The impugned order is founded. The first one is the judgment and order passed by the district judge in RFA number 7 of 2022. And the impugned order passed by the senior civil judge was the order passed under section 151 of the CPC, my lord.
Okay, this application under section 151, was it registered as civil suit?
No, my lord.
Then what was the nomenclature?
Nomenclature is, my lord, as your lordship can see, civil suit number 77 of 2018.
That's
77 of 2018 was filed by the respondent number 5 as plaintiff against the state respondents.
Respondent number 5 in the present appeal?
Yes, my lord. Respondent number
In your
5
appeal?
is the in my present appeal, my lord.
In this second appeal,
In the second appeal,
he is respondent number 5.
yes, my lord.
Samuel Lal Rotlua,
Yes, my lord.
son of Lal Kamlova. The plaintiff is Lal Kamlova.
Yes, my lord.
Now it's the son.
Lalkam Lova died during the pendency of the case, and he was substituted by his son, Samuel Lal Roklua, with the permission of this honorable court, my lord.
Where in this?
He was substituted
In the RSA.
in the RSA, my lord.
Okay, this civil suit was filed under what section?
Civil suit was filed, my lord. The plaint also I have. Page 22, Annex of 1 is the copy of plaint.
Because the order says this is an application under section 151.
My lord, this civil suit was filed against the order passed by the Director of Revenue.
Okay, but under what provision?
Uh,
Under 151?
no,
It appears so. The order dated 7/3/2022 says application under 151.
that is true, my lord. This civil suit was filed against the order issued by the Director of Revenue. During the pendency of this civil suit, application under section 151 of the CPC was filed.
It should have been registered separately.
It was not.
It was not registered.
No,
It
no,
was
my lord.
as if the original suit was filed under 151, order has
Right,
been
right.
passed. Now the plaint is at page 22.
Yes, my lord. Page 22 is the plaint, copy of plaint. This suit was for declaration that the plaintiff is the rightful owner of LSC so and so. Actually, his LSC and this
Well, Mr. Lianshima,
is my lord, pro forma respondent.
let us try to understand. The Lal Kamlova is filed. And Rimoy, who's Rimoy?
Rinmoy.
Rinmoy.
He's the LSC of the plaintiff, Lalkam Nova, and Rinmoy was overlapping each other.
Okay, then
So dispute was there
between them.
Between them.
And then the revenue had decided in favor of Rinmoy,
Yes, my lord.
and Lal Kamla was ousted.
Ousted.
So during the pendency, then he challenged the order of the revenue.
Yes, my lord.
Then
And-
during the pendency, he filed 151 application
Yes, my
to
lord.
change the location.
Yes, my lord. The same was allowed.
But let us see what did the revenue do?
Revenue.
Which order was challenged?
Here, as we can see from the post title at page 23, my lord.
No, has it been annexed? Any order has been annexed?
The order has not been annexed here. Actually, that order is not an issue here, my lord. And that civil suit number 77 of 2018 is still pending before the civil court, my lord. At page 23,
Okay,
the cons-
there's something mentioned about verification report,
right, my lord.
19/6/2017. Where do we get that verification report?
That verification report has not been annexed along with the appeal
Plaint.
petition.
It's not there with the plaint.
It is this plaint, a copy of plaint was annexed without annexers, my lord. Those annexers, in fact, are not in issue in the present appeal. That's why we did not annex along with this appeal petition.
Nineteen 19/6/17. Nineteen 19/6/17. Where is that? It is annexure 5 to the plaint.
Yes, my lord.
You don't have annexure 5. We have
have
not
not.
annexed it.
We have not
Oh, then
enclosed.
how do we know what is what? Anyway, let us read.
The order issued by the Director of Revenue was challenged because
Which order?
Director upheld the LSC of this Rinmoy, Mrs. Rinmoy,
By which order?
by this that order, that particular order has not been annexed along with this petition, my lord.
No, I don't think that has been annexed in the plaint. Because if you see the prayer portion, in the prayer made in the plaint,
My lord.
there is no mention about any order passed by the director. Only
My lord,
thing,
in the prayer portion, relief is prayed at para 26L for a degree declaring that the actions on the part of the defendant number 1 to 4 in issuing LSC number so and so to the defendant number 5 and their actions in entertaining and considering the defunct house pass number so and so for making out the said LSC so and so is illegal and ab initio, and to further declare that such illegal actions and any order passed in this respect by defendant number 1 to 4 is null and void.
so no order is there. It just says
My
any order. So we don't know which order. Now, this M says the impugn verification report,
My lord.
19/6/17. So impugn verification report probably is performed, I mean, it has been prepared in the form of a chart at paragraph 6 of the plaint.
My lord.
So basically, the LSC of the defendant number 5 was upheld.
My head. Yes, my lord.
So the plaintiff, being aggrieved, filed the civil suit.
Right, my lord.
During the pendency of the civil suit, he suddenly had some bright idea that let me ask for changing the location
Yes, my lord.
so that we don't have to
worry
like
about
sort
that.
of bear all this dispute thing, and
Right.
if location is changed,
My lord.
problem will be solved.
Right, my lord.
Then the learned trial court allowed.
Allowed, yes, my lord.
Yes, direct them, you change the location.
My lord.
And that location change has been done to your land,
Yes, my lord.
over your land.
Yes, my lord.
So that has prompted you to come in appeal.
Yes, my lord.
And what is the decision of the first appellate court?
First appellate court, my lord, decided that we were given the liberty to file fresh at page 3, my lord.
Oh, just a minute, okay.
My lord.
How? Therefore, I hereby direct defendant number 1 to 4, state defendants to transfer alternate the location of plaintiff landed property covered by so and so, located at Punchong Aizol, to the vacant land located at New Capital Complex Road, Zone 1, which is found out by the plaintiff.
My lord. That was the order passed by the senior civil judge. Being aggrieved,
Plaintiff found a plot of land which is vacant in Zone 1.
my lord.
They said, go, please transfer my land there.
My lord.
Then the court says that, okay, state respondents should, defendants should transfer it.
Right, my lord.
Then 7.3. Let us read this order. I don't think it's a very lengthy order.
The
Page
order
1.
of the
Page 1.
page 1, my lord.
This appeal was filed.
Right, my lord. I'm
Please.
reading with lots
Yes.
of permission. Had the parties. This appeal was filed by the appellant challenging the order dated 7/3 to 2022, passed by the learned civil judge 4, Aizol, in civil suit number 77 of 2018. It was submitted that there was a dispute in respect of the land claimed by the plaintiff under a land settlement certificate number so and so located at Punchong, Aizol. The plaintiff, it was submitted, filed a petition under section 151 of the CPC for transfer, that is for allotment of an alternative site. And on being informed that a site at New Capital Complex Road, Zone 1, Aizol, was vacant, the learned court below allowed for his land settlement certificate to be transferred to the said site stated. The site granted to the plaintiff was, however, not vacant, but under ownership and possession of the appellant. It was submitted being properly looked after by him for growing various crops and fruit trees, and that he had already applied for a house pass over it. The grant of the land to the plaintiff, allowing it to be covered by his land settlement certificate number so and so on the premise that it was vacant land, was thus improper and illegal. It was prayed by the appellant that as the impugned order dated 7/3/2022 affected his interests prejudicially, it would be proper to set it aside. The respondent number 5, in whose favor the transfer of the land at New Capital Complex Road, Zone 1, Aizol was made, submitted in his reply that the appellant was merely an encroacher, having no valid deed of title in respect of the land which he claimed to have been looking after and in respect of which he said that he had applied for a house pass, and that the Government Revenue Authority was competent to grant the land to him in pursuance to the order dated 7/3/2022, passed by the Civil Judge 4, Aizol, in civil suit number 77 of 2018. Duly considered the submissions of the parties, it is the admitted position of the appellant that he was not a party to civil suit number 77 of 2018, and that no evidence was adduced in respect of the affirmance presented in this appeal of his having had possession of the land, which was allotted by transfer to the respondent number 5, and it is undeniable that it would not be within the scope of Order 41, Rule 27, for the appellate court to take evidence in respect of whose avowments made here at the first instance. The parties would agree that as the appellant herein was never a party to civil suit number 77 of 2018, the order dated 7/3/2022 passed therein by the learned court below would not bind him, and he would not be barred by the operation of res judicata to challenging the validity of the impugned order by way of a fresh suit. It would not be possible for this court to grant the appellant the relief prayed for of setting aside the impugned order dated 7/3/2022 in civil suit number 77 of 2018 in the absence of any supporting evidence. The appeal is accordingly dismissed with the observation that the appellant may file a fresh suit before the learned civil judge for Aizol for declaration of his right and title, if any, over the transferred land, if so advised. That was the order passed by the First Appellate Court, my lord.
So this plot of land at Zone 1,
Yes, my lord.
it's a vacant land.
A vacant land.
You don't have a pass.
We don't have a pass.
You're
but
just
we
looking
had
after that.
My lord, we had applied for pass in the year, I've given a list.
You applied?
We had already applied in 2020.
Okay.
2020. The same was lost, and again we had applied in 2021. And survey in respect of the suit land was conducted by the surveyor in presence of the parties in 2021.
Parties means?
Parties mean the present appellant and the neighbors, neighboring landowners.
Okay.
And thereafter, that was done in 2021. And after a year or so, that was on 7/3/2022. Application under section 151 CPC was filed by the plaintiff. And
22.
order was passed on 7/3/2022 by the senior civil judge, allowing the application under section 151 of the CPC. My submission to your lordship is the learned civil court does not have any jurisdiction. On going through the, I have noted down in the petition itself that the section 60,
See, you were not a party in the civil suit,
not a party at all.
but still you can file appeal
Yes, my lord.
as a
We
third
have-
party appeal.
Yes, my lord.
There's a provision for that.
Yes, we have filed.
But you have filed appeal without saying that, isn't it? You just file appeal.
We just filed. Yes, my lord.
You are supposed to take leave of the court.
Yes, we were supposed to take leave
Take
of the
leave
court.
to file a third party appeal.
My lord.
If leave is allowed, then you can file the appeal
My lord.
because you are affected.
Yes, my lord.
CPC says that anybody who is affected by the judgment can seek the remedy.
Right, my lord.
So although you are not a party in the trial court,
My lord.
but since you are affected, then you can file appeal.
Right, my lord.
Now, what has happened in this case? Notice was issued already.
To
Anyone-
the other party, my lord, yes.
Mr. Bill
Respondent
Ramangan is
number
there?
5 is the represented by him, my lord. And government also there, my lord.
I'm for
You are for
respondent
which
number
respondent, Mr. Bill Ramangan?
I'm for respondent number 5, my lord.
Number
5.
Yes.
5 is the plaintiff.
Plaintiff
Plaintiff.
Plaintiff. Okay.
in the suit.
Okay. And state is there also. What do you say in the matter? What is your submission?
Lordship, from my understanding, since substantial question of law is proposed, so once this honorable court formulated, then only at the time of hearing, I think I can object, saying that
Okay.
these are not
All
substantial
right, so we
question of law.
formulate then.
Yes, my lord.
See, going through the substantial question of law, I think 1 and 3 will good enough.
My lord.
B is not, 2 is not required. 1 and 3
Right,
will
my
be good enough.
True, my lord.
I heard, he's right, I heard Mr. L.S. Sharma, learned senior counsel, assisted by Miss Ruth Lalwatfelli for the appellant, who submits that this regular second appeal has been filed by the appellant against the judgment and order dated 18/12/2023, passed by the Court of District Judge Aizol in RFA number 7 of 2022, arising out of civil suit number 77 of 2018. And also against the judgment, also against the order dated 7/3/2022, passed in civil suit number 77 of 2018 itself. Stop. Mr. B. Ramenga, learned counsel, appears for the respondent number
5.
5, while Ms. Van Nesiami, learned government advocate, appears for respondent numbers 1 to 4. Next para, having heard the learned counsels for the parties, the second appeal is admitted to be heard on the following substantial questions of law. Number 1 and number 2. Okay. Page 21A. 1 and 2 will be 1 and 3 actually, okay? 1 and 3. But you will renumber as 1 and 2. There are 3 substantial questions of law, okay? Just listen, Miss Annette. There are 3 substantial questions of law. So we'll only formulate 1 and 3. You'll renumber as 1 and 2 only, okay? This is page 21A, green flag. Not required?
Not required, my
May
lord.
not be-
There is no evidence recorded,
Yes.
nothing at all.
It may not require.
When do we list it? List the matter?
After 2 weeks?
The matter for hearing after 2 weeks.
Yes, my lord.
Oblige.
Obliged.
Item number 4.
Rajabha,
Part heard.
should we take it up at 2? It's 1 o'clock.
Why was it left part heard? I think I have not heard the other side.
Yes.
Mr. Malhotra has already heard, isn't it?
Yes, Yashubha, just a few,
It was regarding that demonstrator.
yes.
Demonstrator.
Sericulture demonstrator.
You were appointed 4 months down the line. You have been again. The
Appointment was
the
cancelled.
appointment is cancelled.
Selection
The
process
selection process was cancelled. Appointment also
cancelled.
cancelled. And the reason was that there was people carrying mobile phones inside. And there was one inquiry done. And based on that report, law department was consulted. They gave some opinion, and the secretary has acted upon it.
Yes.
What would be your case?
My lord, based on the press release which was received by the concerned department, my lord, the inquiry committee was constituted, and upon their findings, my lord, since they, upon examining all the candidates also, my lord, it was evident that some of them were carrying mobile phones inside the examination hall, which was in clear violation of the admit card, my lord. So that is our point, my lord. And if your lordship will allow me to rely on certain authorities of the apex court with regards to
See,
cancellation.
carrying of mobile phone by itself, does it warrant cancellation of the entire process?
No, but upon inquiry, my
No,
lord,
it is not the case, your case, that there were people cheating and all that, and they were seen cheating and all that, using the mobile
the
phone.
findings of the inquiry committee, my lord. There were
No,
two
that's
points.
what.
Yes, my
We
lord.
had briefly gone through the findings.
Yes, my lord.
Where in the inquiry report does it reveal that there was, in all probability, they were at least cheating or something like that? If not saying that they were cheating. And those people carrying mobile phones were identified also. 3-4 persons were there.
After the inquiry, my lord, there were 3 candidates that confessed that they were carrying mobile phones as well, my lord. That is the findings of the
Do
inquiry.
you have any authority to
Yes,
cite?
my lord.
Okay. PK will come back at 2. And as for the main hearing list,
Yes.
unless there's some very urgent matter or short matter, perhaps we'll not be able to take up. There's hardly time.
Yes.
Okay. That's what I've indicated. If they want to wait, they can wait, but court will not be able to take up. That's what I'm saying.
seek your lordship in mentioning one case, my lord. I had filed one IA yesterday in one pending writ petition, and I'm seeking this matter to take up on tomorrow
Aye, for what?
for order.
Orders.
Just emergency, my lord. In that pending case, my lord, there was an interim order, and some clarification is necessary to be made. If this may be taken up on tomorrow.
Clarification of which order?
The interim order passing the connected writ petition.
Interim order.
Yes, yes.
We'll get it listed before code number 2, 3. Okay.
Much obliged.
Item number 4.
Just a minute. Mr. Malhotra, there are other matters also. Let us finish the other matters. We'll come back to your part. Okay. So it'll take some time.
Item number 5.
Five.
May it please your lordship. Lordship, as instructed upon by this honorable court, the parties have signed the memorandum of amicable settlement. We have submitted, lordship.
Yes.
Yes, Your Lordship. Appearing for the respondent, we have agreed to the settlement.
The parties have signed, lordship, along with the witnesses, lordship.
This was regarding loan.
It was, yes, lord.
Loan. So what is the scheme of the repayment?
Lordship, the details is given in page number 2 of the agreement, lordship. So, lordship, as per the loan amount was 2 lakhs rupees. Out of 2 lakhs, 50,000 rupees has been given back, and 30,000 rupees has been deducted from his account, lordship. And now the remaining 1.2 lakhs is remaining, lordship. Now, out of this, the interest amount is 8.10% per annum for the 3 years, which is 29,160. And now, lordship, as per the point number 3 of the agreement, which is mode of payment, amount of rupees 10,000 is to be deducted from his pension amount per month for 14 years. For 14 months, lordship. And the remaining one final installment of rupees 9,160 was to be given on the 15th month, lordship.
You are a pensioner?
Yes, lordship. An ex-MDC, lordship.
Again, sorry?
Ex-MDC, lordship.
Ex-MDC?
Yes, lordship.
How much do you get in a pension?
Approximately 40,000, lordship.
40?
Yes.
So deduction is 10,000
10,000, lordship.
for 14 months.
14 months.
How much do you owe him, the other side?
Lordship, the remaining amount is 1.2 lakhs. Including interest, that is 149,160 rupees.
The loan amount is 2 lakhs,
2
correct?
lakhs, lordship, yes.
Settlement amount is 1,49,000.
Yes, lordship. That is including the interest, lordship, of the period of 3 years.
What happened to the remaining amount? It's been waived?
Lordship, out of the 2 lakhs, 50,000 has been given back.
Out of 2 lakhs?
50,000 has been given
Already
back.
given back,
Yes,
earlier.
lordship, earlier. And during the pendency of this appeal, lordship, 30,000 has been deducted from his loan amount, from his loan account. And now the remaining is 1.2 lakhs.
So how much has been given? 80?
30,000 has been given back. Sorry, 50. Yes, 80,000 has been given back, lordship.
Out of 2 lakhs, 80,000 already given back.
Yes, given back, lordship.
One was 50, one is 30.
Yes, lordship.
So remaining balance would be 120.
Yes, lordship.
But now by counting the interest, it comes to around 149.
Yes, lordship.
Okay. Then what is this liberty to mention and all that?
Lordship, if they have any other objections or additions, lordship, other than what has been stated in this agreement, lordship.
No, but this is something which is not necessary. Parties shall have liberty to mention the matter before the High Court for any clarification or implementation of this settlement.
So Lordship, we added this clause just because just in case, other than what have already been accepted in this agreement, if there is any other addition which the other party wants to mention.
Please write heard Mr. Samuel L. Pacho, learned counsel for the appellant, and Miss
Vanal Chandami.
Vanal Chandami, learned counsel for the sole respondent. The learned counsels for the rival parties submit that the parties have decided to settle the matter amicably out of court. And that a memorandum of amicable settlement has been duly signed by them. To support their submission, the learned counsels have produced the memorandum of amicable settlement dated 21/7/2026, signed by both the parties in front of two witnesses and their respective counsels. The same is being abstracted hereunder. You have to abstract the entire thing. You have a soft copy?
Yes, we do, Lordship.
Give her a soft copy, it'll be easier.
Yes.
Next para, considering the above. No. Before that, you write like this. The learned counsels appearing for the rival parties submit that in view of the amicable settlement arrived at between the parties, the instant appeal may be disposed of in terms of the said settlement. Upon in view of the submissions made herein above, and also in view of the settlement arrived at between the parties by themselves amicably, the appeal stands disposed of in terms of the said amicable settlement. How many copies have you prepared?
We just prepared just one original copy, Lordship, and the rest is photocopy of the original, Lordship.
This copy will have to be retained, or
Well, Lordship, let the Honorable Court, let it be in the records, Lordship, since we already have the photocopy of the original, Lordship.
this will be retained here. A copy of the original memorandum of amicable settlement. Oh, you should have prepared two copies and given one Xerox copy to the court.
Lordship, it's our mistake, Lordship.
No?
We could prepare a second copy with the same registration number since we already have the physical copy, Lordship. In the meantime, during the...
See, you prepare a second copy.
Yes.
Both of you retain the original copy.
Yes, Lordship.
You submit the Xerox copy.
Okay, Lordship.
A photocopy of the memorandum of amicable settlement be submitted by the parties for retention in the records. It can be done? Learned Standing Counsel LADC, appearing for respondent numbers 1 to 3. Further 1 week time is granted to file affidavit in opposition. List again after a week.
Item 7.
Lordship, similar prayer. However, Lordship, I seek 2 weeks' time regarding the matter.
Okay, same order, but 2 weeks.
And my lord, interim order may continue, my lord.
Interim order passed earlier to continue till the next date of listing.
Oblige.
Item 8.
May it please your lordship. Lordship, I'm appearing on behalf of my senior for the respondent number 4 to 6, my lord. Then PSC, if I may be given 3 weeks time to file my affidavit in opposition.
All right, as paid for by Miss
Daphne Lashoitlong, my
Daphne
lord.
Lalfoitlongi, learned counsel, appearing on behalf of Mr. J.C. Lanunsanga, learned counsel, representing respondent numbers 4 to 6. Further 2 weeks' time is granted to file counter affidavit. List again after 2 weeks.
Item 9.
May it please your lordship, I appeal for the appellant. My lord, I humbly submitted that the appeal may kindly be admitted, and the respondent has not yet been served in notice, so I pray that this be.
Just like that. You say admit, then we'll admit it. What is your case? You have to submit.
It is RFA 26 of 2026.
What is the case about?
Your lordship, it is this present appeal is against the impugned judgment and order dated 23/4/26 passed by the learned civil court, in which the learned trial court directed a 50-50 distribution of the fixed deposit account between the appellant and the respondent left behind by the appellant's husband. That fixed deposit account was not assigned any nominee.
So what is wrong with the judgment?
The learned trial, your lordship, the learned trial court erred in applying section 31 subsection 4 of the Mizo Marriage, Divorce and Inheritance of Property Act. The act says that if the head of the family has no son, then the property will be divided equally between the surviving wife of the head of the family and the unmarried daughters who are living with the surviving wife. Here in this case, my lord, the respondent was not living with the surviving wife nor her father till the day of his demise.
It's a succession case.
Yes, my lord.
The parties are what? Husband, wife?
Yes, my lord. Initially, the respondent was.
Petitioner is Lal Ramruati,
Yes.
then respondent is...
Zorin Moy.
No, it's MS, ME Lal Ramruati again.
Yes, my lord, but she was substituted by her daughter Zorin Moy because she died in 2024.
MS means what? This is a company or something firm?
No, this is the appellant's illegitimate daughter.
Oh, the nomenclature, it says M/S. What does it mean? It's a firm?
No, my lord.
Or there's a typing error? Mrs. is written as MRS. Miss is written MS. Dot. Out here it's M/S. So what does it mean?
My lord, it is, I think, typing mistake.
It's a typing mistake.
Yes.
Are you sure?
Yes.
The fixed deposit was made by John Lianzama.
Yes.
Who is he? How is he related?
He is the husband of the appellant, Ramruati, and the
So-
father of Emil Ramklangi.
So the rival parties are the wife and the daughter?
Yes. But my lord, Emil Ramklangi, she is the daughter of John Lenzava in his previous marriage.
Previous marriage.
Yes.
Who is the appellant here?
Ramruati, the latter
Okay.
wife.
The second wife.
Yes.
Amy is from the daughter from the first wife.
Yes.
Okay. Amount involved is how much? 10 lakhs.
Yes.
And who has filed the succession? You have filed.
Yes.
What is the ground taken by you? What is the ground of appeal?
So, Your Lordship, apparently it is Section 31, subsection 4, and by virtue of Section 33, it says that the one who supports till the last breath of his or her with the deceased property will have a first preference in inheriting the property. So, in this case, the appellant alone,
Section
Section 33
of the Inheritance of Property Act.
of the Mizo Marriage, Divorce and Inheritance.
Or Mizo Marriage and Divorce.
Yes.
Where have you stated that? Okay. Is it 18? Paragraph 18?
Point number 10, my lord.
Where have you stated it?
My lord, it is on page number 7 of Memo of Appeal.
Paragraph?
It is point number 16.
What is your good name?
Jailer Ramphoni. Jailer Ramphoni.
Sorry?
Jailer Ramphoni.
I can't hear you properly. What is wrong with the microphone?
Jailer Ramphoni.
JLL Ramphoni? No, the microphone is not loud actually. Anyone is controlling it. It's such a big hall. Please write heart Miss JLL Ramphoni, learned counsel for the appellant, who submits that the appellant, being aggrieved with the judgment and order dated 23/4/2026, passed by the Court of Civil Judge, Senior Division, Roman 5, Aizol, in succession certificate number 951 of 2016, has filed the instant appeal. By invoking section 17 bracket 2 bracket small b of the Mizoram Civil Codes Act 2005, read with section 96 and order 41 of the Code of Civil Procedure 1908. Stop, next para. The learned counsel submits that the appellant is the second wife of late John Lianzawa, while the respondent is the daughter from the first marriage of late John Lianzawa. Stop. Late John Lianzawa left behind a fixed deposit of rupees 10 lakhs.
Yes, ma'am.
Without making any nomination. And the appellant, being his legally wedded wife, applied for a succession certificate for the said amount. Stop. However, the learned trial court, by ignoring the provisions of the, what is that act?
My lord, section 31, subsection 4 and 33 of the Mizo Marriage, Divorce and Inheritance.
Ignoring section 31 bracket 4 and section 33 of the Mizo Marriage, Divorce and Inheritance of Property Act, 2014, had equally divided the fixed deposit in favor of the rival parties. Stop. Aggrieved, the appellant is before this court. Next para, issue notice. Returnable by 3 weeks. Appellant to take steps for service of notice upon the sole respondent by speed post. What about Dusty? Can you serve?
Yes, my lord.
As well as by way of Dusty within 10 days from today. The appellant shall thereafter file an affidavit to show proof of service. List the matter again on. See, any evidence was taken or not? We don't know. 17th of August.
Much obliged.
Item number 4.
If I'm allowed to recapitulate, Your Worship.
Yes.
If I may take Your Worship to page 51. This is the inquiry report.
OP, you may go. $51.
Yes. Your Worship, the background of the case. It's all given here. The background of the case, subclause A, advertisement to the post of sericulture demonstrator was issued by number so-and-so dated 17th of February 2025. 4 numbers of vacancies, permanent post sericulture demonstrator, and recruitment of sericulture demonstrator was conducted by sericulture department in 2 phases. Firstly, written examination was held during 8th to 9th April 2025, comprising of the following papers. Paper 1, English and General Knowledge. Paper 2, Computer and Mathematics. Paper 3, Sericulture. Secondly, interview was conducted on 7th of May 2025 in the office chamber of Secretary to Government of Mizoram Sericulture Department. Final result was published on 8th of May 2025. Appointment order was issued on 9th of May 2025. 41 candidates applied for examination, where 3 candidates were absent in the written examination. Accordingly, 38 candidates appeared in the examination. Eventually, 32 candidates were called for interview. Written examination for recruitment of sericulture demonstrator was conducted. So Your Worship, after this appointment on 9th of May, at page 52, Your Worship, a complaint letter addressed to the President, Secretary MZP, Aizawl Mizoram, was submitted in the name of P.T. Lal Swanoma, roll number 28, Zembabok, Benglai, on 9th of May 2025. Accordingly, on 13th of May 2025, MZP General Headquarters convened extended office bearer meeting at MZP Pisapui and alleged that some candidates failed to submit their mobile phones and had their mobile phones with them during the written examination, and demanded Sericulture Department to probe into the matter and to constitute inquiry committee before 21st of May 2025. MZP General Headquarters issued a press release on 13th of May 2025. Press release indicates that the said recruitment process violates the Mizoram Direct Recruitment Conduct of Examination Guidelines 2018. Serial number 24, instruction to candidates. So on the basis of the press release, if I take your lordship to page 49. Page 49, Annexure 11, the respondents had constituted the inquiry committee. 2 members were appointed, and the terms of reference, number 1, to investigate violation, if any, of the provisions of the Mizoram Direct Recruitment Conduct of Examination Guidelines 2018 and subsequent amendments thereto in the recruitment of sericulture demonstrator under Sericulture Department, Government of Mizoram. Number 2, to investigate any omission in the conduct of the said examination. Thereafter, Your Worship, next page, page 50, is the report of the inquiry committee. This was submitted on 24th of June 2025. The findings of the inquiry committee at page 66, Your Worship. Findings and recommendation.
You said?
Yes, page 66, we find the findings and recommendations of the inquiry committee. If I may read, Your Worship.
Yes.
The findings. The inquiry committee, after thorough investigation within available information and sources, concluded the investigation with the following facts and findings. The inquiry revealed that 3 candidates, Angela Lalrin Moy, roll number 2, Walal Sung, roll number 34. In fact, this should be roll number 36. Lalrem Sanga, roll number 12, confessed that they carried mobile phone inside the examination hall in the first day of examination, which was not permitted and violates instructions to the candidates point E in the admit card issued to the candidates. It appears that the official, not attempting effectively to prevent the candidates from carrying mobile phone inside the examination hall, even though one candidate, Walal Nienga, roll number 37, stood up and verbally complained and requested to conduct physical checking. This is a serious lapse and error committed by the conducting officials, which is violation of para 20 subclause 6 of the Mizoram Direct Recruit Conduct of Examination Guidelines 2018. Number 2, one candidate, Walal Nienga, submitted a written complaint to inquire into conduct of paper 1 examination to the director on 11th of April 2025. The matter was not brought to the notice of the administrative department, which appears to be a serious lapse on the part of the directorate, as withdrawal of the case by complainant neither influenced nor satisfied other candidates. Further, its flare-up, suspicious, and resort to submit complaint to the MZP and eventually to the department. Recommendations: examination of paper 1 and 2 may be conducted afresh to ensure free and fair competition under a close vigil of the administrative department in order to avoid complaint in future. Investigation revealed no irregularities established in paper 3 and personal interview. Number 2, officials detailed and directly involved in the examination hall of the above recruitment examination may not be deployed again to maintain virtuous examination atmosphere. So the recommendation was to re-hold the examination of paper 1 and 2, Your Worship.
What happened to 3? There was no problem.
There was no problem with paper 3 and the personal interview. If Your
How is
Lordship
that?
will-
How is that?
Your Lordship will see the recommendation.
No, you've read the recommendation, I understand, but why paper 3?
Paper 3 was conducted on the next day.
Correct. So that day there was no mobile phone.
There was no mobile phones. There was physical frisking.
Frisking that day,
Yes,
that's
that
why.
day.
Okay.
And after this, Your Worship, we'll see at page 68, the opinion of the law department was taken. And the matter regarding reconduction of examination potentially leading to cancellation of sericulture demonstrator's appointment order under sericulture department has been examined in the law and judicial department and is hereby returned with an advice to carefully consider the findings of the inquiry committee in light of the 4 key principles laid down by the Honorable Supreme Court in State of West Bengal versus Baisakhi, Bhattacharya, Chatterjee and others, dated 3/4/2025, which are as follows. So these are the principles laid down by the, and then Your Worship will see at page 69, decision was taken by the respondent number 2 to cancel the entire selection process and cancel the appointment orders of the petitioners. This is the notification dated 29th of August 2025. And on the basis of this, at page 70, the Director, Sericulture Department had cancelled the appointment orders of the petitioners. And with regard to the inquiry report, Your Worship, what I'd like to submit is that altogether 35 candidates' statements were recorded out of 38.
How many?
Out of 38 candidates who appeared for the examination, the statement of 35 candidates was recorded.
Okay.
And out of these 35 candidates, 10 candidates had deposed that they have no complaint against the fairness of the examination. Serial number Serial number 4, 5, 6, 7, 14, 17, 31, 32, 33, and 35. Now, if I take your Lordship to page 54. This is the statement of the candidate C. Zhou Sangfui, roll number 9, serial number 4. If I may read this, Your Worship. I am Zhou Sangfui, daughter of so-and-so, regarding recent recruitment examination of sericulture demonstrator. There seems to be irregularities as some are using mobile phone inside the examination hall. I appeared in front of the inquiry committee and these are my statements. It seems that they are utilizing mobile phones to answer. While a request to conduct physical checking, invigilators said that all of you are mature and not necessarily conduct checking. I did not carry mobile phone in examination hall. My preparation is not sufficient and not doing well. To earn experience, and I'm fond of the department. I appeared in the examination. I did not have complaint and problems on it. So very clearly, serial number 4, I did not have complaint and problems in it. Again, serial number 5 also, Your Worship.
That's okay. You don't have to read all.
So, yes. So
10 out of the 35
yes,
have no complaints.
yes. And then none of them are eyewitnesses. In fact, the 3 candidates who admitted to carrying mobile phone, that is roll number 2, 12 and 36, that is serial number 1, 14 and 24. They themselves admitted to carrying the mobile phones. But none of the 35 candidates whose statements have been recorded have stated that I was an eyewitness. All of them saying that I'm not an eyewitness to someone carrying a phone inside. Regarding petitioner number 1, Your Worship, the serial number 10, had stated that he had seen her cheating. At page 55, if I may take also page 55, serial number 10, Lalsan Dama.
Yes.
I am not an eyewitness. After we finished forenoon session and during lunch break, it was conversed that some candidates found cheating in the forenoon session. Before starting afternoon session, one candidate stood up and requested to conduct physical checking to prevent from possessing mobile phone in examination hall, but no response on it. On behalf of candidates, a complaint was submitted to the department on 14/4/25 and no response on it. Result was declared on 2nd May 20. Again, I am not an eyewitness. I was in the front row. What I can mention clearly is that roll number 25 had cheated, and there are about 5 witnesses. Although he is not an eyewitness, he stated that roll number 25, petitioner number 1, had cheated, and there are about 5 witnesses. Examination was unfair as instructions to candidates clearly indicated the admit card that carrying mobile phone inside the hall is not allowed, and no checking was conducted, even though requests from the candidates. Coming from Saitwal, engaging 10 years in the department temporarily and approaching overage, I resigned to apply for other job. If re-examination was conducted, I wish to appear again. So, although he is not an eyewitness, he just stated that roll number 25 was guilty of cheating. With regard to this complaint against respondent number, roll number 25, Your Worship, if I may take Your Worship to serial number 20 at page 57.
No, you see, you said 35 candidates were examined.
Yes.
10 candidates have no complaints. Who are these 10 candidates who doesn't have a complaint?
Serial number 4567.
4567.
1417.
1417.
3132.
3132.
3335.
33 and 35.
These are the serial numbers, Your Worship, not the roll number. This is the serial number.
A serial number given in this report.
Yes. Yes. And regarding this allegation against respondent, petitioner number 1, Your Worship, if I may take Your Worship to page 57. Bottom of the page, serial number 20. Samuel Lalpekima, Silo. I was sitting at the back of roll number 25. I don't see her cheating. So clearly, he was sitting just behind roll number 25, who's the petitioner number 1, and he has clearly stated, I don't see her cheating. In the forenoon, there was no checking. In the afternoon, one candidate, Lalni Iyengar, stood up and requested for checking, but invigilator said that you are mature and not necessary to check. Reportedly, someone could not answer properly as they perceived cheating of others. Roll number 25 was having urine problems, and invigilator gave her medicines. She went out 2 times for washroom, and invigilator never escorted her. I consider it unfair, and I wish re-examination. This person has clearly stated that he was sitting behind her and he did not see her cheating. And Your Worship, the statement of the department officers were also recorded. At page 60.
Who is roll number 25?
Roll number 25 is, Your Worship, the petitioner number 1. Her statement is at page 56.
Petition number 1.
Serial number 16 is petitioner number 1. Her statement recorded is at page 56, serial number 16. Shall I read you?
No, it's okay.
Then Your Worship will see.
No, you have already submitted the other day, Mr.
Yes.
Malhotra.
What I'd like to submit
I'll
regarding the complaint submitted by the petitioner number 2 and why he withdrew it.
Why did he withdraw?
Because he was not an eyewitness. Page number. Your Worship, the complaint submitted by him is available in the affidavit filed by the
Page
state.
35. 35 is the withdrawal.
Yes, sorry.
34 is a complaint.
34 is the complaint. Shall I read?
They're not required.
Yes. But he withdrew it because he was not an eyewitness to any person carrying the
You
mobile
may
phone.
sum up, Mr. Malhotra.
Yes.
Basically, we
Yes.
have heard
So basically, Your Worship, now the law concerning cancellation of selection process has been the latest judgment of the Supreme Court in this case of State of West Bengal versus Baisakhi Bhattacharya. They have considered the previous judgments of the Supreme Court, and after considering all the Supreme Court judgments, they have summed up in para 19. Your Worship, a copy of the judgment is available, I think, in the case record. The last occasion I had produced it.
Yeah, it's here.
Yes. From para 7 onwards, Your Worship. Number of Supreme Court judgments have been analyzed and reviewed, Your Worship. Now, if Your Lordship wants, I can take Your Lordship through all the paragraphs, but the main, the relevant paragraph is paragraph 19.
Let us go to that. 19.
They have discussed all the previous judgments. Para 19, Your Worship. The following principles emerge from the aforesaid discussion. When an in-depth factual inquiry reveals systemic irregularities such as malice or fraud that undermine the integrity of the entire selection process, the result should be cancelled in its entirety. Or, if and when possible, segregation of tainted and untainted candidates should be done in consonance with fairness and equity. The decision to cancel the selection en masse must be based on the satisfaction derived from sufficient material collected through a fair and thorough investigation. It is not necessary for the material collected to conclusively prove malpractice beyond a reasonable doubt. The standard of evidence should be reasonable certainty of systemic malice. The probability test is applicable. Despite inconvenience caused to untainted candidates, when broad and deep manipulation in the selection process is proven, due weightage has to be given to maintaining the purity of the selection process. Individual notice and hearing may not be necessary in all cases for practical reasons when facts establish that the entire selection process is vitiated with illegalities at a large scale. So, when the selection process suffers from fraud and large-scale illegalities, then the decision to cancel the selection process can be made. In our case, there's no decision of the inquiry committee that there was systematic fraud in the entire process. There were illegalities committed in a large scale. Nothing of that sort is present in our matter. The only finding is that 3 persons have carried in their mobile phones. Those 3 persons can be singled out and they can be punished. The tainted can be segregated in this case. And at para 1, 19 subclause 1, it clearly says, if and when possible, segregation of tainted and untainted candidates should be done in consonance with fairness and equity. And regarding the second finding, the petitioner number 2 had submitted a complaint which he had later withdrawn after the director had called him. That's because there was a valid reason. He was not an eyewitness. He went along with the others who complained that there were some people using mobile phones. But none of them is an eyewitness, Your Worship. Even he was not an eyewitness. So that is why he has stated that he has withdrawn his complaint. So based on this Supreme Court judgment, unless there's a finding that there was large-scale illegality, cheating or something involved in the examination process, and there was systemic fraud committed by the candidates. I mean, I don't think that this is a case where the entire selection process should be cancelled. And apart from that, Your Worship, the petitioners have been working for 4 months before the cancellation order was issued. And no notice was given to them before cancellation of their appointment orders. There's again a violation of principles of natural justice. They were appointed on 9th of May 2025, and the cancellation orders came out on 3rd of September 2025, after 4 months nearly. And no show cause notice was given to them as to why their appointment orders should not be cancelled. So there's a clear violation of principles of natural justice laws. And the Supreme Court has held, yes, it is within the discretion of the government to cancel selection process and appointments, but there should be large-scale illegalities committed, and where the tainted can be segregated from the untainted, then the question of cancelling the entire selection process does not arise. That's the main.
All right.
Please, my Lord.
Yes.
My Lord, if we look at the inquiry report, my Lord, it was earlier submitted that 10 of them had no complaints, whereas the rest have complaints, which goes to show that, my Lord, there were a lot of irregularities in the examination conducted in paper 1 and paper 2, my Lord. Now, although the petitioner number 2 withdrew his complaint, my Lord, if we look at the inquiry report at page 23, my Lord, the stage 23 of my affidavit in opposition, my Lord.
Oh, you have also annexed
Even I have annexed the same, my Lord.
Okay.
Page 23, number 26, my Lord, the statement of roll number 38. Vanlal Ruata, my Lord. Out there it was stated that, out here, if I may read, it is a short paragraph, my Lord.
Yes.
I was sitting in the middle of the extreme back row. I found that some candidates carried mobile phones inside the examination hall. We tried to complain and we could not find invigilator in the office. We informed those who are in the office and they promised to convey to them. Before we started afternoon examination, my friend Vanlal Ni Enga, which is the petitioner number 2, man, of Saitwal stood up and complained to the invigilator, but they announced that carrying mobile phone is prohibited. After examination is over, we discussed, and some candidates also said that some are using mobile phones. As a result, we decided to submit complaint. We entrusted Vanlal Ni Enga to submit on our behalf. He then withdrew prior to interview. After declaration of result, we decided to complain again. Those who possess mobile phone inside are number 1, Lal Sansua, number 2, Vanlal Suanga, number 3, El Rakheli, which is the petitioner number 1 again. Now, my Lord has gone into all the evidence given by the candidates, my Lord. And majority of them has said that there were irregularities in the conduct of the examination, my Lord. That is my first point, my Lord. Now, the inquiry committee was conducted, and if we look at the findings, my Lord, which are Lordship has already gone through the findings. At finding number 1, my lord, page 30 of my affidavit in opposition.
Yes, what does it say?
If I may read point number 1 and 2, my lord.
Yes, read.
The inquiry revealed that 3 candidates, Angela Lalrin Moi, roll number 2, Van Lal Suanga, roll number 34, which is supposed to be 36, my lord, and Lal Ramsanga, roll number 12, confessed that they carried mobile phones inside the examination hall in the first day of examination, which was not permitted and violates instructions to the candidates, point E in the admit card issued to the candidates. It appears that the official not attempting effectively to prevent the candidates from carrying mobile phone inside the examination hall, even though one candidate, Vanlal Nienga, roll number 37, stood up and verbally complained and request to conduct physical checking. This is a serious lapse and error committed by the conducting officials, which is in violation of para 26 of the Mizoram Direct Recruitment Conduct of Examination Guidelines 2018. And number 2, one candidate, Vanlal Nienga, submitted a written complaint to inquire into conduct of paper 1 examination to the director on 11th April 2025. The matter was not brought to the notice of the administrative department, which appears to be a serious lapse in the part of the directorate, as withdrawal of the case by complainant neither influenced nor satisfied other candidates. Further, its flare-up suspicious and resort to submit complaint to MZP and eventually to the department. Now, if we look at the recommendation, my lord, at point number 1, examination of paper 1 and 2 may be conducted afresh to ensure free and fair competition under a close vigil of the administrative department in order to avoid complaint in future. The investigation revealed no irregularities established in paper 3 and personal interview. And at point 2, officials detailed and directly involved in the examination hall of the above recruitment examination may not be deployed again to maintain virtuous examination atmosphere. So this is the findings, my lord, based on all the statements taken from the candidates, my lord. So, based on this inquiry report, my lord, and as the notification dated 29 August 2025 for cancellation was issued, my lord. With your lordship's permission, if your lordship will allow me to rely on 2 authorities of the Apex Court.
Yes, what are they?
It's the first one is 2002 5 SCC.
2002, 5
5 SCC 533. Paragraph number 8, my lord. If your lordship will allow me to read, it's not a very lengthy paragraph, my lord.
Yes.
Paragraph number 8.
Read.
Further, even if it was not a case of mass copying or leakage of question papers or such other circumstances, it is clear that in the conduct of the examination, a fair procedure has to be adopted. Fair procedure would mean that the candidates taking part in the examination must be capable of competing with each other by fair means. One cannot have an advantage of either by copying or by having a foreknowledge of the question papers or otherwise. In such matters, wide latitude should be shown to the government, and the court should not unduly interfere with the action taken by the government, which is in possession of the necessary information and takes actions upon the same. The courts ought not to take the action lightly and interfere with the same, particularly when there was some material of the government to act on way or the other, one way or the other. Further, in this case, the first examination was held on 19/4/1998. The same stood cancelled by the order made on 15/5/1998. Fresh examinations were held on 11/7/1998 and results have been published on 29/7/1998. Interviews were, however, held on 29/7/1998. In such cases, the events have taken place in quick succession. The parties have approached the court after further examinations were held and after having participated in the second examination. It is clear that such persons would not be entitled to get relief at the hands of the court. Even if they had not participated in the second examination, they need not have waived till the results have been announced and then approach the tribunal or the High Court. In such cases, it would lead to very serious anomalous resulting involving great public inconvenience in holding fresh examination for a large number of candidates, and in Anantapur district alone, nearly 1,800 candidates were selected as a result of the examinations held for the second time. Therefore, we think the High Court ought not to have interfered with the order made by the government on 15/5/1998 in cancelling the examinations and holding fresh examinations. My Lord, and the other one is 2021. Sixteen. SCC 217, paragraph number 15, my Lord.
Yes.
In Goshil Vishavaraj Anubhai versus State of Gujarat, the court held purity of the examination process, my Lord. Para 15, my Lord. Purity of the examination process, whether such examination process pertains to assessments of the academic accomplishment of suitability of candidates for employment under the state, is an unquestionable requirement of the rationality of any examination process. Rationality is an indispensable aspect of public administration under our Constitution. The authority of the state to take appropriate measures to maintain the purity of any examination process is unquestionable. It is too well settled a principle of law in light of the various decisions of this court that where there are allegations of the occurrence of large-scale malpractices in the course of conduct of any examination process, the state or its instrumentalities are entitled to cancel the examination. This court has on numerous occasions approved the action of the state or its instrumentalities to cancel examination whenever such action is believed to be necessary on the basis of some reasonable materials to indicate that the examination process is vitiated. They are also not obligated to seek proof of each and every fact which vitiated the examination process. These are the two citations, and I'm relying on the same citations which was earlier submitted by my senior counsel, Malan. On the same state of West Bengal versus Vaishaki Bhattacharya, my lord, which was earlier produced. The same paragraph, my lord, 19.
Yes.
The first part of paragraph 19.1, my lord. When factual inquiry reveals systematic irregularities such as malice or fraud that undermine the integrity of the entire selection process, the result should be cancelled in its entirety, my lord. My lord, my submission is that based on a complaint, a press release was made and accordingly an inquiry was conducted. And it was the finding of the inquiry that there were problems in paper 1 and 2, my lord. And the findings are also accordingly made by the inquiry committee, my lord. So as a result, the
All right.
Your Worship, if I may give a short reply.
I think that's
yes, my lord.
that's all.
Yes, ma'am.
Your Worship, the learned additional AG had read out the deposition of serial number 26. In fact, what I'd like to say about this is that serial number 26, although he had stated this, he did not submit any complaint. He did not submit any complaint to the MZP also. And regarding his statement that there were no invigilators, if I may take your Worship to the statement of serial
You're
number.
talking about serial number 26.
Yes, the learned AG had read out the statement of serial number 26.
Roll number 38, my lord.
Yes.
In line number 3, he says, we tried to complain and we could not find invigilator in the office. At line number 3, we tried to complain and we could not find invigilator in the office. Now, if I take your Lordship to the statement of serial number 6, page in the writ petition is page 54. Mr. Francis Lalming Moya, serial number 6. Francis Lalming Moya.
Roll number 11.
Yes, Your Worship. 6th line, Your Worship. Roll number 11, 6th line in his deposition, in his statement. There are 4 to 6 invigilators within such a small hall, and they did very well. So, according to this candidate, there are 4 to 6 invigilators who were present in the hall, which is also very small, and they did very well. So, I mean, Your Worship, it is neither here or there. I mean, the inquiry report. So the findings of the inquiry report, Your Worship, that there was, in fact, the findings is only that 3 people took in mobile phones, and the petitioner number 2 who had submitted his complaint and later on withdrawn, the matter should have been forwarded to the administrative department. So those are sort of matters in between the department and the directorate, administrative department directorate. And when The finding of the inquiry committee is that only 3 people had taken their phone in. Those 3 people can be easily identified. It is not a case where the inquiry committee had come to a finding that there is large-scale illegalities committed, that there is large-scale tainting, where the tainted cannot be segregated. Your Worship, in the judgment of the Supreme Court, which I relied on, if I may kindly read para 11. State of West Bengal versus Baisakhi Bhattacharya.
Yes, read.
Para 11, Your Worship. If I may read, para 11. Similarly, in Union of India versus Rajesh P.U. Puthu Valan Kathu, this court examined a case where a special committee scrutinized answer sheets of 134 successful and 184 unsuccessful candidates, identifying only 31 as involved in unfair practices. Based on this, the court struck down the decision of the competent authority to cancel the entire recruitment process, deeming it extreme, unreasonable, and unnecessary given the circumstances. The court applied the test of whether there were widespread, pervasive issues that had undermined the entire process, and whether it was impossible to weed out those benefiting from the irregularities or illegalities. Again, Your Worship, in para 12, another decision of the Supreme Court in Inderpreet Singh Kalon versus State of Punjab has been discussed. And if I may take Your Worship to para 13, the last sentence in para 13. In this context, it was observed that termination orders should only be issued in cases where it is found to be impossible or highly improbable to separate the tainted cases from the non-tainted cases. Again, para 15, Your Worship. Similarly, in another 2-judge bench decision in Joginder Pal versus State of Punjab, this court observed that every effort should be made to separate tainted from untainted candidates, and if it is found that segregating the tainted from untainted is possible, cancellation of entire selection process would be incompatible with law. So the Supreme Court has held on a number of occasions when the tainted can be segregated from the untainted, then the entire selection process should not be cancelled. In our case also, if we go according to the inquiry report, the tainted are only 3 as per the findings of the inquiry report. They can be singled out and they can be punished. There's no finding that there were large-scale illegalities committed by all the candidates. And the allegations against the petition number 1 also is, there's no finding on that by the inquiry committee. And lastly, Your Worship, my learned friend's judgment which he has relied on, I think the facts are totally different. There, I think there were findings that there were large-scale illegalities committed. That is not the case in our present case here.
All right. We'll consider. And heard Mr. A.R. Malhotra, learned counsel for the petitioners, and Mr. Samuel Valarskete, learned additional advocate general, appearing for the state respondents. Hearing concluded. Judgment reserved. Court Master, can you get me the printed copy of these 2 judgments? Okay.
Your Lordship is here tomorrow or leaving tomorrow?
No, I'll leave on Sunday.
Okay.
Perhaps sister is leaving tomorrow.
Okay.
Sister
Yeah,
Jo.
I think. Thank you.
Large scale, small scale. Ah, ini emak.